People v. Franklin. Counsel?
May it please the court, John Castellano for the office of Melinda Katz. I'd like to reserve 3 minutes for rebuttal, if I may, Your Honor.
Yes, sir.
Thank you. I appreciate that. Your Honors, the defendant's statements about his own residence in the CJA report were properly admitted under the Confrontation Clause because that CJA report had the primary purpose not of producing evidence against the defendant at trial, not of aiding in a police investigation, not of gathering evidence for the prosecution, but instead simply of providing information to the arraigning judge for about the defendant's community ties.
So is the standard that you're asking us to look at the primary purpose one?
Yes, Your Honor. We are asking you to do that, and the reason that I am relying on that test is because, among other reasons, Ohio versus Clark. In Ohio versus Clark, long after the forensic cases, 3 years after Williams versus Illinois, 6 members of the court sign on to a decision that says that the primary purpose test is not just important or even essential to the analysis. They say it is a necessary condition of finding that a statement is testimonial. So what they say is that only if a statement has the primary purpose of actually producing an out-of-court substitute for trial testimony will it be deemed to be testimonial.
I'm wondering why you're going through this whole Confrontation Clause analysis to begin with, because the statement you're talking about is a statement of the defendants.
Yes, Your Honor, absolutely. It is a statement of the defendant.
So can you point me to a case holding that the Confrontation Clause applies to a statement of the defendant?
I'm not aware of that case, Your Honor.
Is it clear?
Yes.
I'm sorry.
No, go ahead. Is it clear from the record whether the statement is entirely the defendant's as opposed to his mother's?
There are actually 2 statements. So they're the statements of the defendant, and that.
I mean,
yes.
with respect to the word basement, which I take it is the point that's in contention, yes, or BSMT, whatever the abbreviation was.
Right.
Is it clear from the record whether or not all of the contents of the form come from the defendant as opposed to any of the contents coming from his mother? Where in the record would I find that?
In the description of the process, of the protocols by Oscar Morales, who's the CJA supervisor, it says, and it says on the document itself, actually, that all of the information in white is coming from the defendant. And he says specifically that information is put into a tablet, and that information is then part of a program, and then there is the telephone call to the mother for verification purposes.
And so
I'm sorry.
Go ahead. I take it that because there was no cross-examination of the person who actually took the information, who did the interview, those statements from Morales about the process are all we have to be clear that there was no substantive information taken from the mother. Is that right?
Yes, Your Honor.
Okay.
Yes.
Counsel, to go to the Chief Judge's question, in this record, did you make that argument? Did the people make that argument that these are the statements of the defendant, admissions, or is that anywhere in the record when the parties discuss whether this can come in?
We did not make the argument that the only declarant that matters is the defendant. It was kind of agreed by all that the defendant's statement was an admission by a party opponent and therefore admissible. Even the defense attorney says, my argument would be hollow if you actually brought in the person who filled out the form. So the argument is directed, and just to be clear, what we're arguing today is that if you look, no matter which declarant you look at, the statement did not have the primary purpose of actually producing evidence against the defendant at trial, which is the standard.
Whether it's CJA or whether it's the probation department, because depending on what region of the state you're in, different people are used to gather the same information.
Yes,
this is not just about where do you live, how long you live there. It's about his community ties, his job, his drug use, the extent of his residence, how long he's been there. So it goes beyond. It's a conversation. The interview is having a conversation and is gathering information from it. Where in the record does it state that the interviewer got basement from the defendant versus the verification part where the mother says, yeah, he lives with me, but he's in the basement. How do we know? How do we know that that wasn't coming from I think her name is Mapp?
Yes.
Versus the defendant. He could have, because in this pedigree information, I think, to the arresting officer, he just gives an address. He doesn't qualify that by saying, I'm in the basement. So there's something between what he says to the interviewer and what the interviewer gathered from Ms. Mapp that is not clear in the record.
I would disagree, Your Honor, because there is testimony in the record that says that the information that is on that part of the form, the white part of the form, and it says it on the form itself, is directly from the defendant, and that information...
How does that, Mr. Morales, who is the person who is talking about the process, how does he know what that interviewer meant when they put basement? Was it an afterthought after they spoke with the Ms. Mapp, or was that from the defendant directly?
That was from the defendant directly because that is the protocol. Everything that appears in the white part of this document, as the document itself says, is directly from the defendant.
How does he
and that
know
appears there.
that the interviewer followed the protocol?
Well, that is an issue that is something that would apply to any business record. We know that business records, because of Crawford itself, are ordinarily non-testimonial. But for any business record, you would always have that question. When you introduce a business record, you talk about the protocols of the business, how those entries are made into that document, and then that is, I guess, you would call it circumstantial evidence of that the protocols were followed, and that is what
But whether
happens
we accept it as a business record or a public document, that's separate and apart, and whether or not the statement is in there is testimonial. The two are separate.
They are separate, except that one of the indicators of whether a statement is testimonial or not is whether it's a business record.
So
Crawford
based on
itself-
what you
Yes,
just
sir.
said, Mr. Kessler, would it be fair to say that even though the information might be that the information contained in the white section comes from the defendant personally, that it's still subject to some sort of credibility determination as to whether the proper procedures were followed, and that's in fact where the information is coming from?
Well, and defense counsel argued in summation that we don't know where that information came from. However, because we laid the foundation for it as a business record, and because the purpose of the document was simply to provide information to the court for arraignment, it is
Go
not
to
a
that
testimonial
point,
statement.
and your red light is on, but with the Chief
Yes, sir.
Judge's
Thank
permission.
you.
Let's talk for a minute about the business record and the double hearsay issue. So what is your response to the argument that, okay, put aside the confrontation problem for a moment, but that this is double hearsay?
Both from not from a confrontation clause problem,
Not
from
from
a
a
business record problem? The first level of hearsay is the defendant's statement. That is, it is admission by a party opponent. As long as you have, I think the objection is that defense counsel made in their response.
Again, I have the same response then to that, is where in the record do the people make that argument?
Your Honor, I think that's from the very beginning, from the very start of the,
But I think they make it in terms of a confrontation argument or something, but not in terms of the business, right? That's how I read the transcript, and I may be wrong.
If I may, Chief, just briefly to follow up. The only place I see in your briefs where it looked to me like you were suggesting you preserved it, but I'm not sure if this is what you're referring to, is in your reply at page 27, note 5, where you say the prosecutor argued throughout the colloquy that the purpose of introducing the report was to admit defendant's self-reporting of the place.
Exactly.
Is that intended to, should we read that, or can we read that as preserving the argument in response to the hearsay problem? That
Yes,
it
Your
is the
Honor.
defendant's own statement?
and that was really throughout the colloquy, from the very beginning. She says, this is for the purpose of self-report, of the defendant's self-report. That's an admission by a party opponent. And that would fall within, and in every other part of the colloquy.
And with respect to the mother, if
Yes.
we were to conclude that the record, that Morales' testimony doesn't sufficiently pin down whether basement came from the mother or the father, do you concede that there is no ground on which the mother's statement could have been admitted? What about the hearsay objection vis-a-vis her testimony?
The business records hearsay exception, that statement was admissible as part of the, as a public record. In other words, as part of the public record. The only objection that was made to the public record hearsay exception in the trial court was that the CJA official was not a court official. And that is conceded now by the defense in their brief on page 22. They specifically say that the CJA official was a public official, and they cite the very case that we cited in the trial court. So from
I
a
thought you
hearsay
were
exception point-
proceeding
Yes, sir.
just now on the view that it was a business record, not a public record, which I
Both.
think is
And in
distinct.
fact, the trial court found that it was both a business record and a
Okay.
public
But
record.
so nothing specific. You were explaining to us, I think, that with respect to the defendant's statements in the course of the interview, that those are his own statements, and whether that's preserved or not, we would have to, I think, ascertain. But if we were to conclude that the mother, or there's an open question about whether the mother provided substantive information on the form, not just verifying it, is that not hearsay as well? And if so, is there a response to that?
That could be hearsay. Nevertheless, it is admissible on this record as a public record, independent of the business records.
So your view
exception.
is that a public record has, there's no hearsay objection that lies to a public record?
I'm not saying that there's no hearsay objection that lies. I'm saying that there wasn't a hearsay objection made.
Was this an argument that was developed on the record in the trial court, whether it's a public record? I mean, you said that the court made a finding that it was both, so I assume it was argued in the record?
It was, Your Honor.
And your position here is that all the requirements for admission of a public record were met?
My position here is that the only objection that was raised by the defense counsel in the trial court was that the CJA official was not a public official, was not a court official, is specifically what he said.
So we have some
The only
unpreserved, we might have some unpreserved other aspects of what constitutes a public record.
Correct, Your Honor. And for that, if you reverse, the appellate division can consider those unpreserved arguments. We're not contesting that. But this court, of course, could not consider those unpreserved arguments.
Thank you, counsel. Oh, sorry, you had a question.
Just one last thing. Didn't counsel raise the objection that it's not a business record, it's not a public record, it's bolstering? And the last objection was it violated the confrontation clause. There were 4 areas in which counsel made an objection.
Just to focus on the hearsay exception of a public record, there was only one thing that he argued with regard to that, and that was that the CJA official was not a public official within the meaning of the Public Records Clause, and that everything else is unpreserved, and the court found it was a public record, and therefore the exception would apply. Thank you, Your Honor.
Good afternoon, Hannah Kahn for Respondent Sid Franklin. Usually in constructive possession cases, an officer gets up and testifies about all the things they found near the gun, the defendant's license and his Con Ed bill and the mail with his name and address on it, and all these things, none of which implicate the Confrontation Clause. And the only reason we're here is because they didn't find anything near the gun that tied Mr.
So what
Franklin.
makes the CJA testimonial, the CJA report?
I'm sorry?
What makes the CJA report testimonial?
Right, so the CJA report is a document that is made, after the client has been arrested and accused. It's made for use in a court proceeding, so it's extremely solemn, it's very formal. That's what, Crawford tells us are the key attributes.
Does it have a permanency in the proceeding? From the beginning of the proceeding, from what Mr. Morales said, that the person's using a laptop, taking information as they ask the questions from the defendant, then they load it on a computer, and then there's a verification process. And the court, the prosecution, defense, that becomes a permanent part of the defendant files. It follows him throughout the entire prosecution. Is that correct?
That's absolutely correct.
So, based on the criteria that it has to be, as far as the primary purpose, used for at trial, what does the at trial, have we ever defined what at trial means? Is it that stage, or is it the guilt stage? What does at trial mean?
Well, first, I respectfully disagree that the primary purpose test is applicable here, or that it requires something to be used at trial. In Crawford, which this court just relied on a couple months ago to define testimonial in People v. Ortega, the court gave kind of 2 ends of a spectrum of testimonial and non-testimonial. And on the one end, you have things that are always testimonial, things that are, pretrial statements and things said in preliminary hearings, affidavits. And then you have things that are never going to be testimonial, like offhand remarks. And I think that the primary purpose test is a tool to decide all the stuff that falls in the middle of that. But you don't need to apply the primary purpose test when you have something that is so clearly falls within a testimonial. This is made for use by the court.
Let me ask you the same question that I started with earlier, which is, do you know of a case you can point me to that holds that a defendant's own statement made out of court is subject to confrontation clause analysis?
I believe in the brief there were several cases that we cited about defendants with interpreters, and they did find that it was subject to confrontation.
That's because there's an interpreter in the middle there, right?
Right, and here you have the CJA representative in the middle. The CJA representative is the one who's deciding what to put on that form. The defendant doesn't see the form as the CJA representative is filling it out or after.
So your view, just to give you a different example, let's take this out of the CJA context for a minute, is if Mr. Franklin had called up the cable company and asked for cable service in the basement apartment, and the operator at the cable company wrote down that in the application that's where the service is going, and they sent a crew out there and he got cable service, that record could not be admitted against him unless you could get past the confrontation clause analysis.
No, Your Honor, because someone who is making a report for cable, isn't making something for use in a court, right? So the difference is...
But that is the confrontation clause analysis that you're going through then. You're saying that wouldn't just go through a normal hearsay exception analysis.
Right, but I guess I would just say that it wouldn't be testimonial, correct?
So what would the remedy be usually if it's a confrontation clause violation, to pick up on the Chief Judge's issue? Okay, so the people say, fine, we're going to call the defendant because he's a declarant, right? And he takes the fifth, I'm imagining. So what happens then?
Then they can't use the information. But I don't think that this was my client's
But
statement.
why can they use it because he's unavailable?
Well, I think that all of this entire line of questioning about whether it's his statement is assuming that it is in fact his statement, that any of the stuff on the form is his statement. We don't know that.
So why isn't the Morales testimony sufficient on that point about the process?
Because he wasn't there. Because you need to call the person who actually, spoke to these people. As anyone who's been in arraignments know, that protocol isn't followed in every single case. We have humans here. Humans are doing these interviews. Sometimes they're under a lot of time pressure. And whenever you introduce humans, you introduce variation. And
So
you
that's
introduce
actually an interesting point, because that was, I think, referred to below as well, that if you had actually called the person, if the people had called the person who had filled out the form, there'd be no issue here? Is that, I think I heard you sort of say the same thing.
Well, I think that if they had called the CGA representative who filled out the form, that representative could testify about some of the information in the form. The representative, I don't think, could say, what his mother said, because that would be hearsay. But I do think that...
Right, I thought I understood you, and I thought I understand counsel below to have said, had they called the person who filled out the form, who was speaking to Mr. Franklin, right, and filled out the form,
Allegedly.
Sorry?
Sorry, just if he was speaking to Mr. Franklin. I just don't want to assume that.
Okay. Had there been such a person who did that, right, that if that is what was in the form, there would be no issue here at all, not simply no hearsay issue, but also no confrontation clause issue. Did I misunderstand that?
I don't think so. If you called the actual person who filled
Yeah.
out the form, I don't believe there would be a confrontation clause.
And so why would there be no confrontation clause issue in that case?
Because you could cross-examine the declarant. The person who filled out the form is the declarant, and you could cross-examine.
So you're not saying the declarant here is Mr. Franklin?
No, I don't think the declarant here is Mr. Franklin.
What statements, I suppose you have a question about whether the statements were the mother's or the son's, but whose statements were they, if not one of those two?
That's the problem. We don't know. We don't know who else the CJA representatives are in the courthouse all day. We don't know who else you could have spoken to.
No, but I think she means in terms of the confrontation clause, I think Judge Halligan is asking. So whose statements are we concerned about in terms of the confrontation clause?
I think that, so we're concerned with the actual person who filled out the form. And I would want to ask that person where he or she got that information, because...
Isn't that a standard business records cross, not a confrontation problem?
No, and I would also add that this does not fall within the business record exception to the hearsay rule, because even assuming that it was his stepmother or Mr. Franklin that gave this information, they don't have any business obligation or duty to report. So it's not...
That goes to, I think, to whether there's hearsay within the business record. Does that go to whether it's a business record?
Yeah. Yes, I do. I believe that under
You
Jonathan
can't have a
Phillips-
business record that has information within it that comes from someone else, even if that person is not someone under a duty to have, filled out that form or duty to the company or the employer. I thought you could have that. The question then was whether you have a hearsay objection to the substance of that information within the business record.
Right, so the substance of the information could not come in, but that's what we're concerned about.
Okay, but you're not, I don't take you to be arguing, but tell me if I'm misunderstanding, that it is in some respect not a business record. I take it your objection is to what you view as hearsay within the business record, is that right?
Yes, the information in the form could not come in.
So the defendant's statement is hearsay, is what you're arguing?
No, but I don't know that it is the defendant's statement here. That's the problem, is that we don't know that it
Well,
is the
counsel,
defendant.
if the court is satisfied, leaving that part out of it, if, as a general rule, a business record that contains hearsay within it, you would have to remove or make some sort of remedy for the hearsay within the business record. However, one of the exceptions to hearsay is an admission, and that information, to the extent the court was satisfied that it came from the defendant, would then become an admission within the business record, would it not?
Well, information if it did come from the defendant, but not information that came from the mother, for example. And there's a lot of information on that form beyond just the BSMT, which is obviously very damaging, but also, the fact that he lived there for 3 years, that's very prejudicial too. He's much more likely to know about a gun in a storage closet if
But
he's
the
lived there for 3
operative
years.
information for purposes of this appeal is simply, where does he reside?
I'm sorry?
Isn't the question here his residence and nothing more than that?
No, the question is admission of the form, and on the form, there are several pieces of really damaging, prejudicial information. And in fact, this was really the only evidence that tied him to the basement.
Counsel, and I think that's the key point in the back and forth in the colloquy, the defense lawyer focuses on BASMT or whatever the abbreviation is. But if we have a double hearsay problem here, and you have a business record, let's assume this is a business record, but you have statements from a third party not under a business obligation to report, right? One of the exceptions we've been talking about is statement against interest, statement of the party opponent, this defendant. But another hearsay exception in that context, as I understand it, is did the person with the business duty verify the information that comes in? So, for example, you come into a hotel, you register, you give your name and home address. I ask for your license. That's hearsay, right? I'm writing it on the form. You just want to come in the hotel. But I ask for your license, and I look at the license, and I say, okay, that's the address and information, and I put it in there. Do you agree with that?
I think so. I'm sorry, I'm having trouble following.
One of the ways to get around a double hearsay, to satisfy a double hearsay problem with a business record, is if the person recording the information, who has a business duty to record,
Right.
taking information from a third party, makes sufficient efforts to verify the third party information. Do you agree with that general rule?
Yeah, if the,
So my example was a hotel clerk takes the license and verifies your name, and let's assume the address is on the license. So that would be a verification, right?
right.
Why can't we look at this record as the defendant provides this information about his address and the mother verifies it?
Because we don't know that it was him who provided it, and we don't know what the mother verified. Did she verify BSMT? Did she verify 3
If
years?
she didn't verify BSMT and he wrote it, then why do we have her as a problem here then? So you're saying, okay, so BSMT isn't verified. That would be your position.
I don't think, right, we don't know what's verified, and we don't know that it came from my client.
And your argument for purposes of the business record issue is that if the preparer of the document had been called, then we would have been able to verify those facts?
I think some cross-examination
Did
could have
you-
revealed that, yeah.
Some cross-examination could have also questioned that, couldn't it?
Right, but I think that in this case, we don't have any of that information, and there was a significant confrontation clause problem here, because this is a form that is, it's created for use in a prosecutorial proceeding that is testimonial, and forms that are being used during a prosecution, during a court proceeding made for that purpose are very solemn, and they are subject to
This form wasn't made for
confrontation.
the purpose of prosecution to elicit evidence. This form was to help judges in verifying community ties when they're setting bail. Just because it's relevant, it becomes relevant at some point later. It's not the same thing. This isn't a prosecution document.
I disagree with some of that. I think that, respectfully, I think that this does very much have a prosecution purpose. This is, an arraignment is is a prosecutorial setting, but beyond that, what is the purpose of these forms? What is the purpose of gathering all this information? It's to make sure that defendants show up for trial. It's to make sure we can prosecute them.
What is the purpose of keeping it in the file and making it a permanent part of the record?
Well, I would argue that weighs more heavily in favor that this is testimonial, right? It follows the defendant through, it's given to the prosecutor, it's given to the judge. For all those reasons, I would also just add that,
What is the purpose, the arguable purpose that the document's prepared for?
What is the reason?
Purpose, yeah, why do they do this?
To advise the court during arraignment.
Right.
So-
And that goes to bail conditions and those types of things, conditions of
Yes.
release?
Yes.
So is it possible there would be another motion for bail or an adjustment of conditions that this might be relevant to?
Probably,
And that might be a reason to keep it in the file, right?
maybe.
Do you disagree with your adversary's position that the people adequately preserved the argument that the declarant made these statements? The brief references several points about the defendant's self-reporting.
No, I don't think so, because.
So why isn't that enough?
Why isn't it enough that they mentioned at the trial that he self-reported?
In the
Because-
course of discussing, I think in the course of, you can correct me if I'm wrong, I think in the course of discussing, though, whether it was appropriate to admit the form.
Because you can have information in a form that comes from one source, but the declarant of the form is another source. And they were never arguing that the CJA, that the information only came from the defendant. In fact, they said, oh, hey, the form is admissible under the business record rule because, the CJA rep, it has a business obligation. The CJA rep, is a public official. So if this document only contains information from my client as they contend, I actually think that creates more problems for them than it solves. And no, it was not preserved. They certainly never argued that this didn't violate the Confrontation Clause because it was his statement. I do just want to add very quickly, we don't believe that the primary purpose test should apply here for all the reasons we said. Very recently, the Supreme Court in Hemphill said that confrontation applied to a plea colloquy, and the purpose of the plea colloquy was certainly not to be used later in another defendant's trial.
Would it make a difference if the defendant allegedly gave those statements, but there was no verification, because that form is created and is a permanent part of the court files? Would your argument be different as far as confrontation? And it would be, as he said, a party admission, because there's only two people in that conversation. There's not a third person. Would it change?
No, because again, I think we're still assuming that there are only two people involved.
No, I'm saying if there was no verification, there was no one to verify, and the form indicates, you didn't have a number for me, there's no one to verify. Would that make a difference?
I don't believe so, because I think that the CJA representative could have still gotten that information from somewhere else, and we just don't know. And Mr. Franklin was acquitted of the intent to use. He was never seen with a gun, and he was tried and convicted, despite the fact that his father had a gun license. He was tried and convicted based on BSMT, and I think that I think the prosecution can do a little better before we send someone away for 4 years and take a father away from his son. So I'd ask that this court affirm the appellate division, and if this court decides to reverse, I'd ask that you remand it so that the appellate division can decide the claims on appeal that were not reached.
Thank you.
Thank you.
Your Honors, I'd just like to start out by saying that, Your Honor, Justice Garcia's question were actually part of the colloquy during the discussion of the business record. So in other words, the ADA at trial specifically said that the reason that it was reliable was because there was a verification by the mother. So that argument was preserved, was made with regard to the business records foundation for this document. Secondly, as far as the applicability of the primary purpose test, I would point the court to Ohio versus Clark, which is after Williams versus Illinois, where 6 members of the court say in the non-forensic context, they say that that test is a necessary condition, not just important, but a necessary condition. So only if a statement has the primary purpose of acting as a substitute for trial testimony will it be deemed to be testimonial.
What does it mean at trial?
At trial, I think, means at trial. In other words, a determination of guilt or innocence.
Has any court defined what that means?
Sorry?
Has any court defined what that means?
Well, the courts have certainly applied it in a number of contexts, and in no context that I'm aware of have they said that that means at any court proceeding, at a court proceeding where you don't even necessarily have a right of confrontation. At arraignment, you don't have a right of confrontation. You have due process rights, no doubt, but you don't have a right to cross-examine whoever it is who comes into court and may make a statement at that point in time. At a trial, you do. That's the nature of the Sixth Amendment right. It is a trial confrontation right.
We might be able to debate whether the CJA form was intended for use at trial, as a lot of these questions have brought out, but would there be any debate that it's not intended for use testimonially?
It is not intended for use testimonially, because testimonial means, according to Ohio versus Clark, 6 judges of the court says that it means that it is a substitute for trial testimony. They use those exact words.
Right.
But even if you were not to apply the primary purpose test, and if you were just to look at all of the facts and circumstances here, if I just may have a moment with regard to that, you have Morales' testimony. You have actually a statement on the report itself. There's a legend on the report itself that says the purpose of this, or that this report considers community ties and bench warrant history. It does not consider, according to the legend on the document itself, it does not consider weight of the evidence.
What about counsel's comment that there's no way to know for sure whether or not the CJA interviewer was talking to her client as opposed to someone else, without the ability to cross him or her?
The protocols that were laid out by the CJA supervisor, the regular business protocols of the CJA agency, established that that statement in this white area of the form came directly from the defendant. And then there were follow-up questions on redirect that said that as far as the mother's verification.
But I took her to be saying maybe it was someone else altogether. Maybe I misunderstood, but that you can't be certain who it was without speaking with her.
But you can, based on the protocols, based on Morales' testimony, because it specifically says that information, that specific question is asked of Morales. Where does that information about residents come from? That comes from the defendant while the CJA interviewer is sitting in court, sitting in the cell with the defendant and inputting that information on the tablet. It all happens together. It all happens at the same time. It is near the time as any business record would be.
My last question, too, is based on the standard, which talks about under the circumstance would lead an objective witness reasonable to believe that the statement would be available for use at a later trial. Why wouldn't the interviewer, an objective person, that shoe wouldn't believe that it would be used for later proceedings?
While that is one possible test.
Since they're making it a permanent part of the file.
I understand, Your Honors. Couple of things about that. One, and I'll just refer to that as a reasonable expectation test. That test is, has been used in the forensic context. In the non-forensic context, every single no court has used it. The Supreme Court, this court, has not used the reasonable expectation test in the non-forensic context, not Davis versus Washington, Michigan versus Bryant, People versus Dews, People versus Peeler. In addition to that, the test has a danger of swallowing the whole primary purpose rule. And I think that's why it's not used. Because what it says is, if you look at it as broadly as a foreseeability issue, is it foreseeable that this could be used at trial, then it completely swallows the primary purpose test, because primary purpose says it has to be the intent, the purpose, to be used at trial. And so it would cover the reasonable expectation test, all of that, plus a whole lot more. We would need the primary purpose test, and yet the primary purpose test is the test that the 6 members of the court have signed on to in the non-forensic context. With that, I would also like to point out in Ohio versus Clark that the court says that statements that are made to someone who is not principally charged with the uncovering or prosecution of a crime are much less likely to be testimonial than otherwise. So these are all the facts and circumstances that you could point to with or without the primary purpose test that point to this statement being non-testimonial. Thank you.
Thank you, counsel.